Just on the Labuskaghni judgment, I note your reply that you said, look, you weren't aware of it at the time of your application. But that judgment was handed down more than 2 years ago. So would you agree that given your position as a judge and the expectation, I suppose, from people who appear before you and the general public that judges know the law, that there's an expectation that you keep yourself abreast of developments in the legal landscape, and especially when it comes to judgments of the higher courts?
Yes, I do agree.
And especially given their binding nature on the lower courts.
Yes.
So does your explanation not admit to shortcoming in that regard?
Not at all, because sometimes you get to know about your own judgment when you're researching a certain point, when you're preparing a judgment. You don't always follow up on each and every matter that you've granted leave to appeal on. Once the matter leaves your desk, there are so many things, or there are so many matters that a judge should attend to at the High Court. The work is moving very fast.
No, sure. I take the point. I think my point is rather that regardless of whether you actively follow up on your own judgments, there are services in which the various courts circulate judgments on a daily basis to those who subscribe to them. So it's very accessible, especially with SAFLI being open source facility. What I'm saying is that in the normal course of familiarizing yourself with the latest judgments of the higher courts, you should have come across this judgment and said, hey, wait, but that looks familiar. I remember that case. And what I'm saying is your explanation perhaps reveals a shortcoming in that regard in the general continuous updating of yourself with the developments in the law.
Yes, I do update myself in the development of the law. I check all the cases that are delivered, for instance, by the Supreme Court of Appeal and by the ConCourt. Only if those matters are reported. I don't know whether this matter was a reported judgment, but I didn't pick up that it was a reported judgment. Hence, it skipped my mind, or it skipped my day-to-day looking at the recent decisions that have been delivered by higher courts.
Okay. Thank you, Judge. Thank you, CJ.
Commissioner Malem.
Thank you very much, CJ. I just want to ask you 2 questions quickly, and then I'll tell you why I'm asking those questions. What is your understanding of a judicial temperament?
Judicial temperament. It requires that a judge should be able to listen and take into consideration other people's views and be collegial to others, and not act outside of what is required of a judge.
What is your understanding of collegiality?
Is that colleagues should be should have good relations, and should be able to work well with others.
So when I walked in here, the CJ was still conducting the interview, and the way you were responding to her, at the beginning I thought maybe the CJ explained your relations before I came in, and maybe you know each other from somewhere else, because you kept on interjecting her and not allowing her to finish her points. And I was like, does she have a problem with her or what? But you do that to your colleague again, this side. And this time you don't do to her. You're doing to your colleague. She says to you, no, wait until he has finished his point. But that's what you've been doing to her. Do you define that? You are the one who just said to me now judicial temperament means that you must listen to others. But here you have to be stopped for you to listen to others. Interject the most highest office when it interviews you. Is that a true reflection of judicial temperament and collegiality at this level in public?
Commissioner Malema, I didn't see that as an interjection. I thought the Chief Justice had finished her questions, and I thought Commissioner Gamble had finished his questions. If I have interjected, I do apologize. It was not my intention to interject.
Thank you, CJ.
Thank you, Commissioner Malem. Commissioner.
Good evening, Judge Mantame.
Good evening, Commissioner.
I'm going back to the Labuskaghni judgment. When Judge Gamble asked you about the Constitutional Court judgment, you responded by saying, "Have you read my judgment?" And I have two questions in that regard. Are you implying that the Constitutional Court got it wrong and your judgment was right?
Not at all, Commissioner. What I wanted to clarify is that perhaps the case that was put at the Constitutional Court is not the case that I was confronted with. That's all.
Well, I'd like to probe that. The Constitutional Court said on the issue of the rescindability of tax judgments. It says that all the authorities which have said those are final judgments and are rescindable were brought to your attention, but you ignored them and didn't follow precedent. Now that seems to be correct from a reading of your judgment and the Constitutional Court's judgment. So what about that was not before you?
You would remember that Metcash dealt with the VAT, with the VAT Tax Act. The matter that was before me dealt with the Tax Administration Act. The Metcash was decided in 2000. The judgments that I relied on were provincial divisions that were recent, and some of them spoke on what was happening in that matter, that they referred to the Tax Act, to the TAA. So the Tax Act TAA, in my view, was addressed more better in the recent judgments of the provincial division, in the judgments of the provincial divisions, than what was at play in the Metcash. Remember, Metcash didn't deal with the rescindability of several judgments. The Concord in that matter dealt with the declaration of sections of the VAT Act unconstitutional.
Well, the court here also comments that you didn't explain that. You didn't actually distinguish. You didn't take into account a whole lot of authority, and you didn't explain what you've just explained now, which I think is correct.
Yeah. That's why I said I do accept that criticism. Sorry.
No, carry on.
Because my judgment was not thumbsucked, it came from precedents from the provincial division.
My second question also relates to your answer to Judge Gamble. And following on from Commissioner Malema, when he asked you about the Constitutional Court judgment and you said, well, have you read mine? Do you think that displays collegiality and an appropriate judicial temperament?
I thought by asking that question, it was going to have a balance on what was before me and what was dealt with by the Constitutional Court. I didn't in any manner try to disrespect Judge Gamble.
Thank you.
Follow up, CJ. Good afternoon, Judge. I'm here.
Good afternoon, Commissioner.
Yes. I just want to follow up on the Labuschagne judgment. My understanding of that judgment, first and foremost, Rogers J was not conclusive in his statement. He said you appear to have not relied on precedent. That's the first point. He was not conclusive about the issue. But that's not the point. He actually referred to a judgment of the Supreme Court of Appeal, or the Appellate Division, the 1973 Appellate Division case, the Kruger case. And in his reasoning, he says that, in fact, in that particular case, the Appellate Division stated it categorically that tax judgments were rescindable. And that is the basis upon which the criticism is based. I'm not sure, do you have any comment on that?
I've seen the judgment that it started analyzing judgments from 1965. Those judgments were not before me when the matter was argued. It was only Met Cash that was put before me.
But was the issue whether a tax judgment can be rescinded an issue before you?
Yes.
But surely that is an issue that can be researched. It might be that the parties themselves, or none of them, actually argue the case before you. But I think if there is authority from a higher court, then one would expect that at least that authority is located, unless perhaps there's a challenge with resources in terms of research and so forth. And I think that's where Rogers J was coming from.
Commissioner, the reason, perhaps maybe I might have appeared hostile in asking whether Judge Gamble read my judgment. The case that was before me was not clear to start with from the applicants. The applicants didn't know which instrument to rely on. Firstly, it was said the application is brought in terms of Uniform Rule 32 to capital B. There's no uniform rule dealing with the rescindability of judgments in as far as that rule is concerned. Secondly, they said they brought the application in terms of Rule 42. Thirdly, they said they brought the application in terms of common law. I was confronted with those three legal instruments, and I had to analyze them all as to which one would be relevant in their case. It seems as if their case was all clear before the Constitutional Court. That's why I'm saying I don't know which case was put before the Constitutional Court, because the papers were in shambles when they came before me. But I do take that today the criticism is on me. It was not a good drafted application that I dealt with.
No, I can accept that. A case evolves with time, and sometimes when it gets to the Constitutional Court, it becomes better explained. I can accept that.
Sorry.
Thank you very much, CJ.
And even wrong legal instruments were quoted, and I had to probe during the hearing. Which Rule 32 are you referring to? Are you referring to 31(2) small b that deals with the...
No, thanks, Judge. I think you have made a point, and I think I agree with you. Thank you very much.
It was a bad
CJ.
case that I had to deal with, Mr. Commissioner.
Commissioner Nugaitot?
Yes, thank you, Chief Justice. Judge Mandama, I just want to come back to this point that you were discussing with Commissioner Steinberg on the Labuschagne judgment, because I'm very worried about the way you've characterized the criticism of the Constitutional Court, because it seems there's one issue that they take with your judgment, which is whether or not you were correct that a tax judgment is not final and therefore not rescindable. Do you accept that?
Yes, because that was my finding.
Yes. Now, on that issue, it doesn't matter whether they characterize it as a Rule 32 or any other rule, because it's a question of law. Now, what they say about what you did is that you failed to have regard to at least 3 judgments that were binding on the issue, despite the fact that those judgments had been brought to your attention. In fact, it's only in the leave to appeal where you referred to Metcash. And the way you did so, at paragraph 29 of the Constitutional Court judgment, you said that the Constitutional Court did not make a finding of law. It just made an observation. This is why they use very strong language to say that your judgment was unacceptable. It's because you poo-pooed, you dismissed, you waved away a binding authority that says a tax judgment is final. That's the criticism against you. In other words, you treated authority of the Constitutional Court as if it didn't exist. So you can find that in the judgment itself at paragraph 29. They come back to that at paragraph 30. They say the reasoning in Metcash, now they're responding to you, on rescindability was not merely an observation. It was an integral part of this court's reasoning. And Metcash, in turn, endorsed the two judgments in Kruger. So that gives us three that were brought to you. You don't apply them, despite the fact that the Concord has spoken authoritatively on the subject. Now, my concern is not so much whether you get the job of being JP. It is what you will do when you return as a judge, bearing in mind the posture you've adopted today about the authority of the Constitutional Court. Can you comment on that?
Commissioner Ngwaito, I'm not sure what attitude I've adopted about the Constitutional Court.
You've said it was a different case before the Concord to the case that was before you, whereas I've just pointed out to you it was exactly the same issue, which is finality of tax judgments. Now, once you don't accept that it was the same issue, my fear is that you will repeat the same error of treating with dismissiveness judgments of the Constitutional Court. If I can just finish this point, maybe then, paragraph 30 says, observance of the rules of precedent is not a display of politeness to a court of higher authority. It is a component of the rule of law, which is a founding value of the Constitution. My fear is that you will not follow precedent.
As I said earlier on, Commissioner Ngwaitobi, that I do accept the judgment of the Concord. I do accept that I'm bound by the judgment of the Constitutional Court. However, there was a lot that I had to unscramble in the court of first instance to reach the decision that I've reached. Maybe it didn't come out clear that I had to unscramble a lot of issues before I came to that conclusion. I did not at all, not in 1 minute, say that I'm not bound by the President of the Constitutional Court.
No, I don't think you said you were not bound, but the approach we've taken before us is that it's because the applicants failed to identify the issue and therefore the issues were different. So in other words, you still don't see that there was an error in your judgment because you got the law on finality of tax judgments wrong. And that's the point I was putting to you.
Commissioner Ngwaitobi, it's not that I didn't see what was in front of me. I was just giving a background as to what is it that I was confronted with. I thought that was going to clarify the issue as to why I came to the conclusion I came to. Not that I want to disrespect or disregard the judgment of the higher court, Apex Court for that matter.
Yes,
I wanted to give a background.
No, I understand that, but the issue is still the same. It's whether or not tax judgments are final. That's the issue before you, that's the issue before the Constitutional Court. So I'm struggling to understand why this background is relevant to that issue. And that's why I fear that you will just repeat the same error.
Commissioner Ngwaitobi, I want to repeat that error. I'm committed to that.